the next case to come before the court is State of Ohio versus Keir and McQuistan. Each side will have 15 minutes to present your argument. As the appellant, you may reserve up to 5 minutes for rebuttal. When you take the podium, let me know if and how much time you want to reserve. The arguments are being visually and audibly recorded to be posted online, so please keep your voice up. Remain behind the podium. Do not use the names of any children or minors, which I don't think has anything to do with this case. We have read your briefs, and we are ready to begin when you are.
Thank you, Judge. May it please the court, Attorney Mike Callow for Keir McQuistan. I would like to reserve the maximum 5 minutes of time for rebuttal argument. In this particular case, Keir McQuistan appears before you for the second time on an appellate procedure. On this particular occasion, we're asking for you to remand the case back to the Medina County Court of Common Pleas and permit us to have a hearing on our motion for post-conviction relief. We have, on this particular case, filed appropriately and timely a motion for post-conviction relief. We have supported that motion with scientific evidence that was newly discovered, which is a requirement, the famous black box in this case. It's newly discovered evidence. We have also submitted an expert report that explains the significance of the black box, newly discovered evidence to the trial court.
What is the significance?
The significance is that Keir McQuistan hit the brakes in advance of the collision, and that Keir McQuistan's vehicle was at least less than 20 miles per hour at the time of collision.
Tell me how either of those factors would play a role in any kind of affirmative defense to an assured clear distance charge.
Well, the important thing in this particular case is that the state's case, and particularly if you look at the closing arguments, the state's case was he was so intoxicated, because remember we didn't have certain evidence in this case, so they were arguing from circumstantial evidence he was so intoxicated. In this particular case, they argued repeatedly he was so intoxicated he never even hit the brakes, which means he was so intoxicated he didn't see the collision about to happen. He was so intoxicated he couldn't control his car, and it turns out from the black box that to be absolutely false. That in fact, the black box records several seconds before the collision that the brakes were hit and the car dramatically slowed.
And how would that be a defense to the assured clear distance?
Well, I don't know that it would be an offense to assured clear distance because, as you know, we all have a responsibility not to hit the person in front of us, barring some emergency like the car coming out in front of us. That's true. But this particular argument was used as part of the totality of circumstances to explain that Mr. McQuistan was intoxicated, which is also part of the case. And in that regard, it clearly prejudiced him because in turn, the states used a false argument because as they kept emphasizing that no brakes were hit, it turns out to be false. The black box confirms. But what we're asking for, Judge, is not for you to determine the final outcome, but to determine that we had a right to a hearing. You know, this is a process type argument that says that we have a right to the legal process. And the legal process here is when you file this post-conviction relief and you've established newly discovered evidence, which we did, this evidence was not available during the trial procedure. We've supported that with an expert opinion that analyzed that so the court knew the significance of it. We've also supplied a legal expert opinion that outlines the various ineffective assistance of counsel claims. We think that we have sufficiently provided the court with enough to say that we get a hearing and the right to civil process. Remember, a post-conviction process is civil in nature, so we would have a right to discover evidence, take depositions with court's permission, and avail ourselves of other civil process. And in this particular case, we've been shut down because the trial court has found that there's an insufficient effort on behalf of Keir McQuistan to get this process started, and we think that's an error, that's an abuse of discretion. If newly discovered evidence of a scientific nature plus 2 expert opinions isn't enough, then what would be enough? There's a lot of instances where less would get you at least a hearing. Now, you may not win in the trial court, but at least you get your hearing. And that's what we're here to ask for, is that you're remanded for purposes of that hearing so that we can further develop and prove the case and prove the significance, have our expert testify as to the significance, and provide the trial court with that evidence so that the trial court can make a decision as to whether or not to grant post-conviction relief. We also, in this case, have made the arguments of ineffective assistance of counsel, again, supported by an expert legal opinion that we provided the trial court, found numerous errors. Particular of importance is the failure to challenge the impartiality of the judge in this case. And what was found by the trial court was that original trial counsel did not sufficiently challenge it or challenge it with the correct procedure. She correctly determined that filing a motion with the trial court is not the proper way to remove a judge from a case for impartiality. You have to file that at the Supreme Court. This appellate court confirmed that that's the proper way to do it in this appellate decision. So we think with two courts finding that, as well as our legal experts submitting that, that is evidence of ineffective assistance of counsel and that Keir McQuistan did not receive a fair trial. Most importantly is that level of support and sufficiency should get us a hearing in the trial court on a post-conviction relief. We should at the very least get a hearing so that we can make these arguments, civil process so we can develop these arguments to support our opinion that there was ineffective assistance of counsel on that situation. So a trial judge saying that you didn't do it the right way procedurally, you missed your deadlines, you didn't do it the right way, an appellate court confirming that the trial attorney didn't do it the right way, as well as we've submitted a legal opinion, we think that we've met our burden to at least get a hearing on that.
Don't you have to show prejudice result? For instance, talk about the missing the deadline. I assume you're talking about the motion for new trial.
Yes.
How was your client prejudiced by that missed deadline?
Prejudice, as outlined in our expert legal opinion, is that he thinks that those matters of ineffective assistance of counsel, in his professional legal opinion, rose to such a level that my client didn't get a fair trial. And that would be in situations like, well, for instance, there was a failure to investigate the black box in a traffic accident. That's really almost unheard of for trial counsel, not to ask for the electronic evidence as to how the car was maneuvered and handled. It's almost unheard of not to find the black box evidence. But further, in a situation where the trial counsel didn't believe that the judge was going to be fair and impartial, he failed to meet the deadlines to challenge that and didn't do it in the proper procedure. Now, the natural consequence of that would be he would have got a different judge, or at least been heard on his right to a different judge, and certainly a judge that was detached from the situation. Remember, the basis of impartiality is that shortly, very shortly after the trial and prior to sentencing, the prosecutor was hired on the judge's staff. Now that creates a situation, certainly of the appearance of impropriety, and certainly is a situation that I think all courts should be avoiding. And in this particular situation, Keir McQuistan lost his right to challenge that because his lawyer didn't file it the right way and didn't file it timely. And we think that that's clearly a prejudice to him. He has that right to challenge that. We think that it clearly was an impartial situation. I would also indicate that when the motion for post-conviction was filed, that the trial judge in that particular case then removed herself for the appearance of impropriety. So we again think that it was pretty clear, and he lost his right because he didn't challenge it the right way.
Are there any factors pointed to during the trial itself that would show bias or impartiality on the part of the judge toward that prosecutor and against your client?
Well, I've been a criminal defense lawyer for 23 years. I think all you judges show partiality to prosecutors. That's always been my position. I don't know that that's more than speculation. No, it would be hard to prove something like that. But I would tell you that as you read the transcript, there's nothing that is obvious that would say that she obviously made rulings in favor of the prosecutor that weren't right or correct. I couldn't say that. I mean, I would tell you my personal perspective, if you ask me my personal opinion, is that that particular situation happened, that rulings were, evidentiary rulers were viewed in the point of the prosecutors or that. But I've been doing this 23 years. I think that happens a lot. That's just my personal opinion. I don't think there's a lot of judges who take the criminal defense lawyer's approach to case law or evidentiary rulings. In this particular case, and I see that the time is moving, but in this particular case, I think that we have sufficiently provided, for purposes of post-conviction relief, enough evidence here with 2 experts, new evidence, enough to get a hearing in the matter. I think it's an abuse of discretion not to permit that. Keir McQuistan is on a 3-year prison sentence. There's a process of post-conviction relief in the law, and I think he has the right to avail himself of that. And in this particular case, he has met all of the burdens that are his to meet, to at least get a hearing and to open up the civil process for his claims. Whether he wins or not is for a different day, but he at least gets the right to do that. And in this particular case, we'd ask that you remand the case back to the trial court and open up that process by ordering the court to grant a hearing and open up the civil discovery process for him. Okay? And I'll reserve the rebuttal of my time. Thank you.
Good morning again, Your Honors, and may it please the Court, I'm Vince Felucci with the Medina County Prosecutor's Office for the State of Ohio, the appellee. I'll start with the crash data report, the black box report. That report would not have helped McQuistan in any way at trial. In fact, it would have harmed it. The report shows that at the exact moment of impact, McQuistan's vehicle was traveling 20 miles per hour. That's what it shows. But just 0.4 seconds before impact, it shows McQuistan's vehicle traveling 27 miles per hour. 0.6 seconds before impact, McQuistan's vehicle is shown traveling 41 miles per hour. Just 0.8 seconds before impact, McQuistan's vehicle is traveling 45 miles per hour. 1.2 seconds before impact, McQuistan's vehicle is traveling 50 miles per hour. 1.6 seconds before impact, McQuistan's vehicle is shown traveling 55 miles per hour. 1.6 seconds before impact. In fact, from 4 seconds before impact to 2.6 seconds before impact, the report actually shows McQuistan speeding up from 53 miles per hour to 55 miles per hour. So basically the report confirms that McQuistan didn't even notice Mr. Robinson's vehicle until 1 or 2 seconds before impact. Really maybe 1.6 seconds before impact, because he's still going 55 miles per hour. At trial, the state never alleged that McQuistan exceeded the speed limit. The state did not have to prove that. The idea that McQuistan didn't go over the speed limit doesn't change any of the evidence, the mountain of evidence showing that McQuistan was at fault in the crash, did not have assured clear distance, as Judge Callahan mentioned, does not change the fact that he was under the influence of alcohol, does not change the fact that he caused serious physical harm and fractured the skull of a 5-year-old boy. The idea that McQuistan applied the brakes 1.6 seconds before impact, which is when the speed finally starts to decrease, that doesn't change the fact that he's at fault in the crash and that he's under the influence. It wasn't mentioned by the opposing counsel here, but the dash cam video of Officer Heidelman is mentioned at length in the brief. I point out that McQuistan's trial counsel actually did object at length to the prosecution playing part of that video during McQuistan's cross-examination. That objection was overruled, of course, but counsel did everything he could to keep it out. And that was sound strategy, because that video was harmful to McQuistan also. McQuistan's petition was a bit contradictory in arguing that playing the whole video would have helped him, yet he should have kept the video out. You can't have it both ways, obviously. But in the video, I will say, either way, McQuistan is seen slurring his speech. At the same time, the video showed that McQuistan was okay enough in terms of being capable of speech right after the accident, because he's shown having a conversation with Officer Heidelman. However, as the prosecutor correctly pointed out at trial, just minutes later when the state troopers show up and start investigating him for OVI, he mysteriously becomes unable to speak. He's not answering any of their questions. In fact, he's staring at the troopers in what they describe as a manner like he wants to fight. So I would say a hostile manner. That's how they describe it. He's slurring his speech. He has glossy, bloodshot eyes. He's unsteady on his feet. He's got a strong odor of alcohol, all the classic signs of intoxication. He refuses to cooperate with any field sobriety tests, will not even look at the officer trying to do the HGN test. Later refuses the breathalyzer. Nothing on Officer Heidelman's dash cam was going to change any of that evidence. It's very compelling evidence. In terms of investigating other crashes in the area, there's nothing specific mentioned in terms of any particular crash. McQuistan just says there were many. He offers no suggestion as to how he would have gone about getting any of that video of crashes that McQuistan wasn't involved in. That kind of evidence would have proven absolutely nothing about McQuistan's crash. In fact, it probably would not have even been admissible because it wouldn't have even been remotely relevant to his case. The fact is that the condition of Greenwich Road, where this accident happened, at the time and place of this crash was not a disputed trial. And this court mentioned that in its direct appeal decision in this case. Cross-examination, even McQuistan admitted that the lanes of travel were clear between the fog lines. There was no snow, no ice on the actual road itself. Every other witness who was at the scene also testified that the roadway was completely clear of snow and ice on that day. And the state also had photographs showing that, as this court mentioned in its direct appeal decision again. In terms of investigating other witnesses that might have been shown on the dash cam of Officer Heidelman, McQuistan provides no evidence about his trial counsel's actual investigation into these individuals, who they are, how they would have helped this case potentially. No affidavits from any of these people that say, oh, I would have testified this way. We do know that McQuistan's counsel called Scott Vallant as a witness. He was a paramedic who responded to the scene and did interact briefly with McQuistan right after the accident. He actually testified favorably for McQuistan. He said he didn't observe any obvious signs of intoxication during his brief encounter. That person was called by defense counsel. And as far as anybody knows, that's the only witness that possibly could have helped him in this case, and defense counsel called him, did everything he could there. So in terms of, I'll move on to the impartiality of the trial judge. This court already rejected that claim in the direct appeal, so that's re judicata. That issue has been decided, so it couldn't have been prejudicial for his trial counsel not to raise it. I think you heard an acknowledgement that there's nothing during the trial that shows bias in favor of the prosecutor, and then, like I said, this court has already decided that. In terms of the ineffective assistance part of this, the allegation is that the motion for a new trial was untimely filed, but the trial court did not deny the motion on that basis. This was not a procedural-based denial. This was a lengthy decision that was issued, explaining why the court wasn't impartial, and then again deciding the case on the merits, or deciding the motion on the merits. In terms of the first assignment of error, the allegation of abuse of discretion to dismiss the petition without a hearing. I've cited in my brief numerous decisions. I wanted to narrow because there are so many where it's upheld when a post-conviction is denied without a hearing. But I only cited capital cases, and there are many that fill up a whole page from this court and from other Ohio appellate courts where the dismissals without a hearing were upheld. They're routinely upheld. And given everything that I've mentioned, dismissal without a hearing in this case was appropriate. It was not an abuse of the trial court's discretion. There was no evidence, there was no new evidence presented that was going to help McQuistan's case in any way. Are there any questions? just respectfully ask this court to affirm the trial court's judgment. Thank you very much.
Please record there's a few things I'd like to mention in the rebuttal. First of all, the prosecutor, appellate counsel in this case, takes a lot of, first point he makes is to interpret for himself what the crash data is, but he has no scientific background. That eliminates him from being able to provide that type of opinion, right? So when he comes here and he says, this is what it sounds, he has no background to do that. I bring that to your attention because that's exactly why you need the hearing, so that experts can review the data and experts can tell you what the data means. We, on our side of the fence, because it's our initial burden, provided an expert report that said that not only was the evidence newly discovered, that's the first step. Second of all, here's what it means, that's the second step. And two, it would have made a difference, and that's the following conclusion that he reaches. The state did not respond with any expert evidence. They didn't respond with any experts saying, no, it's not that, or we challenge that. That's the purpose for having a hearing in this case, because it's not for the lawyers to come forward and tell the court, this is what all that expert data means. It's for a hearing, and that's what we're asking for. We're asking for you to permit us to have a hearing so our expert can say exactly what he's interpreting and what he thinks and tell him why he's wrong. Now, I could tell you also that from speaking with the expert, he is wrong. What am I going to tell you? I'm not an expert either. That's why we're asking for a hearing so that we can go. And I think it's important to get a hearing so that we can determine that. The prosecutor also, I'd like to provide, he says that there's a challenge to the dash cam video. Our challenge is an ineffective assistance of counsel, because as this court has pointed out in numerous cases, and particularly in this case, there's no marking of that evidence. The failure to mark evidence so that the court can review it is almost the definition of ineffective assistance of counsel. If we can't review the evidence on an appellate process, and if you can't review it because we don't know what part or portion of it was played, then that's ineffective assistance of counsel, because it's eliminated my client's right to challenge that. He is prohibited from challenging the playing of that video in portions because we don't know what portions were played, it wasn't marked for the record, and therefore he has lost that appellate argument. That's why it's important. Also, there was an argument made that I'd like to rebut, that we're not aware of any other evidence that would have helped. Evidence like the weather or visibility, slippery conditions, all those things would have been reflected in other traffic reports from that night. There were multiple collisions that night. The reason why some of that isn't presented is for twofold, which are the arguments we're making. One, we didn't have a civil hearing where we could present that evidence.
But how would that have affected the criminal case?
It would have affected the criminal case because remember, in this case, it's a circumstantial evidence case. They're saying my client was intoxicated going down the road based on circumstantial evidence. They're saying he caused this accident based upon circumstantial evidence. And we have a right to present other circumstantial evidence. In this particular case, for instance, Judge, if there was a witness out there who said, I saw him before the accident and he was not intoxicated, that would be important.
But isn't there a difference, Mr. Callow, between offering the statement of that witness in your post-conviction and just saying, hey, there could be somebody out there, therefore we get to try to discover that?
The civil discovery is limited in post-convictions, and most of it you even have to apply to the court to get permission to do it. So it's very limited. It probably should only be considered around the things that you have a good faith basis of investigating, which would be all the things we've delineated in the accounts. So for instance, a witness that talks about the black box, I think that would be important, and I think we've delineated that in our petition. Any witnesses that are shown on the video, they're identified on the video, we know who they are. Defense counsel just never interviewed them. Defense counsel never went and said, what did you see, or what could you testify to? And I think those people are all identified in the video and or identified in the trial when the video portions were being played. And I think those are all important people. And so, I know I have to close here, but the state says, as far as anyone knows, as far as anyone knows, this is all we have. And that's the whole purpose of having post-conviction hearings. The purpose of post-conviction hearings is to give the defendant an opportunity after he has sufficiently carried his burden to have a hearing and present evidence and have access to civil discovery so that we can provide the court with all this information. And that's what we're asking for. So with respect, Judge, I would ask that you remand the case with those instructions. Thank you.
All right, thank you both for your presentations. We will take this matter under advisement, issue a written decision, which will be mailed to both sides as well as posted on our website, and that